Louis Brandeis was born in Louisville, Kentucky in 1856. At age 20, he graduated from Harvard Law School with a grade point average rumored to be the highest in the law school's history. He then moved to Boston and founded a law firm where he often took cases without payment, earning the nickname the People's Lawyer. In 1916, President Woodrow Wilson nominated him to the Supreme Court, where he served until 1939, dying 2 years afterwards in October of 1941. Louis Brandeis fundamentally altered the American legal field through his progressive age work as a public attorney in breaking up monopolies and regulating big business, his work on the Supreme Court in defending individual liberties, and his creation of the now judicial precedent of the right to privacy. Brandeis first gained national attention in the legal field when he and his law partner, Samuel Warren, published an article entitled The Right to Privacy, where he argued that, quote, the right to be left alone be protected by law. This idea of a right to privacy is possibly Brandeis's most influential addition to the field of constitutional law. His most significant case as a public lawyer was against J.P. Morgan's New Haven Railroad. J.P. Morgan was attempting to gain control of his railroad's main competitor, the Boston and Maine Railroad, which, if Morgan had obtained it, would have given him a monopoly on the railroads of New England. Brandeis wrote a 70-page booklet where he argued that New Haven's acquisitions were putting the company in financial jeopardy and that within a few years their finances would collapse. The merger was defeated and New Haven collapsed just as Brandeis predicted it would. In his time as a public attorney, he would also uphold the constitutionality of workplace laws, refine and improve health care for New England, and oppose monopolies and the expanse of big business. In 1916, President Woodrow Wilson nominated Brandeis to the Supreme Court. Critics of his nomination claimed that he was too radical and was too reform-minded to make a good justice, although some of his critics, including Chief Justice William Taft and Senator Henry Cabot Lodge, opposed the idea of appointing a Jew to the Supreme Court. Brandeis's first notable case was Gilbert v. Minnesota in 1920, which dealt with a state law that prohibited interference with military enlistment efforts. In his dissenting opinion, Brandeis argued that that law deprived a person of an important aspect of their liberty and privacy as a U.S. citizen. In Whitney v. California in 1927, which also dealt with matters concerning free speech, Brandeis argued that, quote, fear of serious injury is not a good enough reason to restrict free speech as, quote, men feared witches and burnt women, end quote, and that danger must be imminent for speech to be restricted. Brandeis's most famous case was Olmstead v. United States in 1928. The issue at hand was whether information obtained without judicial approval by federal agents via wiretapping was legal to use in court. The court ruled 5-4 in favor of allowing the evidence to be used. Brandeis was in the minority. In his dissenting opinion, he argued that the Fourth Amendment's prohibition of illegal search and seizure, dubbed by him as the right to privacy, applied to this case, and that the evidence could not be used in court. The ruling of Olmstead was overturned in 1967 with the case of Katz v. United States. Brandeis's idea of the right to privacy has been a central component in cases since, such as Roe v. Wade. In the case of Roe v. Wade, the right to privacy was the deciding factor, as the court wrote that, quote, this right of privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. After his death in 1941, Brandeis's accomplishments lived on. His idea of the constitutional right to privacy became so widespread that it is now nearly synonymous with the Fourth Amendment. In 2009, the U.S. Postal Service issued a new set of commemorative stamps with his image. In the Post Service's announcement about the new stamp, he was described as the Associate Justice most responsible for helping the Supreme Court shape the tools it needed to interpret the Constitution in light of the sociological and economic conditions of the 20th century. Louis Brandeis's contribution to Supreme Court precedent, most notably his idea of the constitutional right to privacy and progressive-era reforms in the public law field, should earn him a place in the APUSH Wall of Fame.